Good morning, everyone. I am Don Bautista, the Executive Director of AC Friends of Court. We continue to serve British Columbians in completing their legal forms in a virtual setting. Every day, our intake crews field requests from the public. And what we have noticed is a palpable sense of stress from these self-represented litigants. Because I suspect for the public, our heads of the justice system continue to be unseen and unheard. So we decided to create this series so that we can allow them to speak directly to you, unfiltered. There are three things we're trying to do with these one-on-one interviews. The first is to inform the public of the interviewee's planning and the thinking behind their planning. Secondly, to tell the public how they're working to even the playing field. And third, to share their reflections on what they're learning now that might be so important to continue after the pandemic. Our guest this morning is Minister Eby, the Attorney General of British Columbia, who plays a significant role in ensuring that our access to justice efforts continue to operate regardless of the circumstances. He has agreed to share with you on what he is doing to help the public, as well to assure British Columbians that even if they come without a lawyer before courts and tribunals, that they will be able to participate in the proceedings in a fair way. Good morning, Minister Eby. Before I ask you my four questions, do you have any opening remarks?
Well, I'd just like to say I'm glad to be here on you with Zoom. You know, it's still a week or so before the barbers really open up, and so you'll get one of my last COVID cut interviews. I'm excited about that, and it's great to be here and to recognize all the work that you do through AC Friends of Court. I'm very grateful for your support for self-represented litigants, and honored to be interviewed by you today.
Well, thank you, and I likewise want to reciprocate our gratitude because you were one of the people who supported our application with the CRA to be recognized as a charity. So thank you for that. Right so on. My first question is, and it might be a little bit too early because it's only been 2 months, but to ask you what lessons you have learned from this pandemic in terms of how you and your officials carry out your responsibilities to the British Columbians that you serve and represent.
Well, there have been a number of lessons, and some of them have been hard, and some of them have been really positive. So maybe I'll start with the hard ones. The hard realities of the pandemic have meant that the weaknesses in our justice system have really been laid bare, and I don't think those will be news to any of your self-represented litigants that you help. But you know, the court system was ticking along and people were able to get in front of a judge and these kinds of things. But the pandemic has really exposed how governments for many years have underfunded the court system and the infrastructure because it is still a heavily paper-based, in-person, face-to-face, 9 to 5, wait your turn kind of process, which is entirely at odds with what we need to be doing according to the public health experts. And it's also a bit at odds with how people live and operate in society now. So it really laid those weaknesses bare. And so that was a hard lesson to learn in real time. And the second, which was the positive lesson out of this, is that in a crisis, the legal community can really pull together and achieve things that are remarkable. I read Lisa Helps recently she's a bencher and a member of the Law Society, and she wrote a Facebook post where she talked about it's as if, you know, a car suddenly unexpectedly started driving sideways. You were able to drive your car sideways instead of just forwards and backwards. That's the kind of pivoting that's happening in the court system. It's a system that nobody thought could change on a dime, and it's certainly not changing on a dime, but maybe it's changing on like a toonie. There's a little bit more space, but it's turning and it's pivoting, and it's a system that nobody thought could actually do that. And so it's a credit to the Chief Justices and the Chief Judge that they are willing and able to embrace the change that needs to happen to serve people in this situation. And there will hopefully be some legacies from this.
Thank you for that. Interesting that you would, I recall the first time you referred to the pivoting. So a lot of the triage work seems to be well in hand, but how do you see transitioning, sort of moving into the next phase where there are going to be more legacy moves, and perhaps to include what you're seeing from the tribunals, which are which operate in a different way?
Yeah, that's a good question. So we have tribunals that have basically operated uninterrupted following the pandemic because their operations were already entirely online. Document management, scheduling, appearances, submissions, everything online. The Civil Resolution Tribunal is the highest profile example of that. Obviously, when you're talking about provincial court or Supreme Court or the Court of Appeal, totally different. So the court that has the smallest caseload, and as a result was able to pivot the most quickly, was the Court of Appeal. They began within weeks of the pandemic shutdown, reopening to hear appeals entirely via Zoom calls. And they expect to be entirely through their pandemic-related backlog by July, which is an astonishing accomplishment. They're sitting extra time to get that done. They have a much smaller caseload. You don't have a lot of evidence from witnesses or juries in Court of Appeals. So they have some real advantages, but it is quite an accomplishment that they'll be back on track as of, they hope, by the end of July. For Supreme Court and for Provincial Court, the situation is quite different. How do we hold a jury trial? How do we hold a trial with multiple witnesses? You have people coming from correctional institutions where there may be an outbreak of COVID, and they have a right to appear in court. And if you're sending someone back to the correctional institution, maybe you're sending them to a setting where they may be exposed to COVID. So how do we consider that? And then for provincial court, you have literally thousands of people, in some cases in a day, but certainly every week passing through our busiest provincial courthouses for traffic, family, criminal, and they come in and they come out and they wait in big rooms full of people, shoulder to shoulder. It is totally a system that is not compatible with the COVID restrictions. And so Chief Judge Gillespie, to her great credit, is really embracing the idea of resolving as many steps as possible outside of court, whether it's family court or traffic or any other matter, resolving as much as possible outside of court before you show up so that only the most essential matters are showing up in front of a judge. And she has some really interesting and innovative ideas about that, and we're supporting her with that work.
So now that we sort of think about the courts, how they operate, and how tribunals operate, what are your thoughts with respect to an asynchronous way of holding court hearings, much in the same way as the Civil Resolution Tribunal operates?
So for those of your viewers who aren't familiar, I imagine they all are familiar with the terminology, but this is the idea that you can appear when you're available and the other party appears when they're available, and you don't have to be in the exact same place at the exact same time in order for the hearing to proceed. And so that's the asynchronous model, as I understand it, that you're talking about. Mm-hmm. There are possibilities for pieces of provincial court to advance in that way, whether on the family side, traffic might be a possibility. So those conversations are taking place with the Chief Judge right now. And it's very exciting, the possibilities that could arise from that. But there are many things that can't be asynchronous in court, whether you're talking about Supreme Court, where you want to be able to hear what the witness is saying about you, and look at your accuser in the eye if you're a defendant, or if you're a judge, they consider part of their work to assess credibility as being dependent on seeing the witness and the defendant and those kinds of things. In family matters, if you're going to have a mediation and try to resolve things, you need everybody in the same place at the same time. The question is for those things, though, could we have hearings, especially for family matters or mediation or support like that, outside of Monday to Friday, 9 to 5 for Supreme Court? Is there a way that we can do chambers so that everyone doesn't have to sit in the same room and go by year of call to decide who gets to go up and talk in front of the judge, and you just sit and wait all day before it's your turn to go up, billing your client the whole time? There are lots of opportunities presented by the public health orders to resolve some long-standing grievances that both self-represented litigants and lawyers have, and anyone who's been through the court system.
And that includes as well the idea of having to walk into the court registry just to file files.
Yeah. I think one of the interesting early accommodations around COVID was expanding the electronic registry, the ability to file documents by email, the ability to, the electronic ID requirements for filing were loosened. So it was easier to get an ID to file online. And the original reason why it was restricted and very difficult to get the electronic ID in order to file online was to prevent an abuse of the court process, to make sure it's not too easy to file documents, and you may have to actually go down to the registry. And it's, in my opinion, we'll see how it turns out, but there has not been a flood of malicious court filings as a result of having filing by email or loosening of the electronic registry. So you're absolutely right. This is a really, this is a legacy piece, I think, where it had to be loosened because of the conditions of COVID. And as a result, we found, maybe some of our fears about what would materialize weren't grounded in reality. So let's look at what actually happened and address the excesses and keep the parts that worked well.
Which allows me to segue to my second question, and that is regarding technology. We've spent a better part of the morning talking about technology as a way to leverage access, but it's not always going to be that easy because it still can be a hurdle. And there are two subsets of our client base that I can think of. The first are those who can't use computers, who in the past, pre-COVID, have relied on trusted public intermediaries like community centers and public libraries to go into their space to file electronically. That's not available to them anymore. Any thoughts?
Yes. So I think that we will always need for our justice system some aspect of people being able to physically attend, to file documents, to make submissions and so on, whether it's language barrier, technology barrier, or something else. This is a required element of access to justice for many people. But unfortunately, I too often hear arguments against against increasing access to justice through technology as being based on, well, a lot of people don't have access to the internet, and we shouldn't be doing this as a result. And that essentially the perfect becomes the enemy of the good is the saying, right? Like, if we can get more access for more people by introducing different technological tools to support even something as basic as scheduling for chambers or for a traffic ticket dispute, and more people are able to access justice in that way more efficiently, then we should do it. But we should also recognize, as you point out, it's not going to be a perfect solution for everybody. So we're going to need to make sure that around the margins that we have space and ways for people to access courts, which is their constitutional right. And it's our obligation to protect that. But that doesn't mean that we can't offer different ways of accessing those courts to different people that have that. At the same time, pre-COVID, you'll know that we were expanding legal clinics across the province. And these clinics, the intention is that the workers who are there, the advocates, are able to help people through online processes, that they're able to walk people through and support them in doing that kind of work, that groups like AC Friends of Court could potentially help people understand where they could access those services and how to do that. And so there is a possibility of building those bridges as well to technology for people who may have those barriers.
Thank you. There's a second group that's near and dear to our hearts and yours as well when you were still practicing at Pivot. Victims of gendered violence. Internally, we've always been saying, they're out there, but they can't be found because they can't step out of the house. I think 2 weeks ago, I had personally, because I was covering the phones for that day, I had to talk to a woman who made the call and says to me, I can only talk to you until such and such a time before my partner wakes up. They're still living in the same place and she can't get up. So there are these people, again, also affected by the pandemic. And I wondered what your thoughts were given, the technological hurdles and the practicalities of trying to get help these days.
Yeah, I think this is a group of people that there's some widespread concern about. I understand that family applications are actually down at a time when a lot of experts in sort of emotional and mental health are saying that there's a huge amount of stress on families, and people who are particularly vulnerable anyway are probably even more vulnerable now and even more in need of court assistance, whether it's around access to children or support or family violence or otherwise. So to see those applications go down at a time when we know that people are more vulnerable and more exposed to the kinds of issues that courts are supposed to be there to support them with is very worrying. And so one of the areas, even before COVID, that I was very concerned about was our family law system. And how people are able to access justice anyway in just a normal setting around family law. And so we have a pilot program that's been at the Victoria courts for a while with family justice workers. We're working with the chief judge to expand that virtually and to get it across the province as much as possible so that people are able to access that even with public health restrictions. It doesn't answer the problem of what a woman does who's trapped in a home with an abusive spouse in a time of restrictions around social distancing, and there's no opportunity. That person's not going to work like he ordinarily does, or doesn't get out of the house like he ordinarily does, and she's essentially trapped there, which is, I think, the image a lot of people have, certainly what I have in my head. And so it doesn't answer that issue, but it does when the restrictions are reduced and life goes back to normal, will help minimize the backlog that people are going to face trying to go into family systems, and will increase the supports that they have to access those systems that might be inaccessible for any number of reasons to them.
So interesting that you use the word support. So just as you know, just before Chief Judge Crabtree moved on to become a justice at the Supreme Court, and before about that same time when Chief Judge Gillespie took on office, this whole idea in the provincial court system that self-represented litigants were given sort of almost, I put in air quotes, rights to bring in support friends, like Mackenzie friends. It's a boon. I've always felt that for our clients, not having to ask the judge first permission if their friend can sit with them to help them, support them, I think this was a huge step. It's still something that I would like to see for the superior courts to sort of adopt, that a self-represented litigant doesn't have to ask permission, because if a friend needed to be there, they obviously have to make time, and they also, more importantly, have to prepare themselves as well. How do you see this sort of taking place post-COVID? Do you think there's...
Yeah, so the supports that I'm talking about are really about helping people understand before they stand up in front of the judge everything that they're going to need to have, all the questions that they're going to be asked, they're going to need to have the answers to, and what kind of supports in the courtroom they're going to need to get through that appearance. Because without that kind of support, you have people showing up in court, and I've watched it. I sat in the courtroom and watched family chambers, provincial court, and people are like, they took the day off work, they're showing up in court, the judge says, do you have this and this? And they say, no, I don't have that. And the judge says, okay, we're going to reschedule you for this date. And they're like, what? this is my 4th time here. I'm here again, and now you're saying I need this, and like, I can't even get this done today. And the judge says, I'm sorry, no, we're gonna have to reschedule you. You can go talk to duty counsel over there. And it is a living nightmare for people. They miss work time, they lose pay, they potentially lose jobs, just trying to get through this incomprehensible court process. So that's the kind of support that I think people need before they show up in front of the judge. And then what you're talking about, that support in the courtroom, recognizing that it's incredibly intimidating and stressful. And this is why Friends of the Court, the original Friends of the Court, were set up, and also why lawyers exist, is to support people in this very intimidating, very process-driven justice system where you got to know the rules. And if you don't know the rules, you're going to be really at sea. Those kinds of supports are critically important. And I agree with you that having those supports is important. And also, you know, it's a difficult thing right now. Across Canada, I'm seeing the restrictions that are being put in place in different courts as they reopen. And one of them is limits on support people. Only one support person with you when you go into court in many provinces in Canada right now because of the risk of transmission of COVID. And so it's a very difficult time around these kinds of restrictions around supports that people need to get through there. And it's an interesting suggestion about this. The Supreme Court. I'll raise it with Chief Justice Hinkson about how we provide those supports and about that initiative taken by the provincial court. It's a very good point.
I also want to take this opportunity to thank you, because earlier on when you classified lawyers to be essential service providers, you were very thoughtful and considerate in saying paralegals are essential service providers as well. And when you talk about support, I wanted to just ask you, because I continue to stand on the sidelines. I think the first time my bottle took you on the side of one hallway was to ask you, Mr. Minister, as far as alternate service providers are concerned and their role in increasing access to justice, what about the paralegals? They're still like being studied yet again.
Yeah, it's very frustrating. So the background on this for your viewers who haven't followed the issue as closely as you and I have, I thought we were very close to seeing paralegals being able to provide some family law services in our province in underserved areas. And the Law Society was, the benchers were supportive. And then there was a vote to essentially not proceed with that and to continue to study the issue. And the reason why this is so important to have paralegals providing the support is because there aren't enough family law lawyers. And those that are there, people can't afford them. And so paralegals are there, they're willing to provide the support and help people get into court and be prepared. Remember when I was talking about how important it is to be prepared before you show up to court, help people get all their stuff together, know what's going to happen. And there was a vote in the Law Society that decided not to move in that direction. I was very frustrated by that. I spoke in support of the paralegal program. Our government passed a law that enabled paralegals to do this kind of work, and not just in family law, in any area that the Law Society felt was appropriate. I continue to support the idea that this is necessary and advocate for it with the Law Society. And you know, I'm a bit frustrated, to be honest, about the decision that was made by my colleagues in law to move away from this direction. I know there's still great interest in it within a significant number of people in the Law Society and in the public. So it's certainly not a dead issue. But it's further away than we thought it was.
Which is, as you know, unfortunate. I can tell you from AC Friends of Court's perspective, the scope of practice areas that we assist in goes beyond family, and it's everything. And I don't want the public to lose hope, but there doesn't seem to be an impetus given, you know, who's running, basically how the Law Society is being run with respect to that. And I appreciate the fact that, you know, you legislated the Legal Professions Act to sort of pave the way for that. And so this is my unscripted plea to find a way to get it done. We are in pandemic mode, so to speak, so there's a bit of loosening of what can and cannot be done. So I will just leave it there and move on to my third question. For the public, their cases are important to them. And as you know, this business of urgent and non-urgent has struck a raw nerve in the public, because to them, the case They've been waiting to have their case heard, only to be told it's non-urgent, and nobody really knows what makes for a case urgent or non-urgent. Any thoughts on this now that it's close to June?
Yes. So for provincial court and Supreme Court, the Chief Judge and the Chief Justice, respectively, are preparing for a significant reopen in the second week of June. And this will enable people to go ahead. We're supporting that reopening with an extensive audit of courtrooms across the province. Is there space for social distancing? Where will people have to stand? Do we need plexiglass here? Which seats need to be taped off to provide the spacing? Where should the council tables be? That is for non-jury trials and potentially for witness trials and hearings. Jury trials and circuit court are an ongoing and challenging issue. Remote communities that do not want anybody coming because they have no healthcare support if they have a COVID outbreak, or very limited healthcare because their doctors fly in and fly out. They don't want to see people flying into their community and bringing COVID with them. So it's very complicated. And for jury trials, the impaneling process where you bring in 100 people to identify jurors from all across the province, and the sheriffs are corralling them, and they go through the vetting process and all of these things, incredibly difficult to do while respecting social distancing. So it's got to be terribly frustrating when there's an existential lawsuit related to your business or your family, or something that happened to you that you've been dealing with for years, and your court date was scheduled for this period and it's been canceled because you're told it's not essential and or not urgent. And for you, obviously, it's of the paramount urgency. And so we're trying as hard as we can with the courts to get those courtrooms open as soon as possible. And we have two problems. One is getting the courtrooms open, and then the other is what do we do with this massive backlog that has built up over the past, since St. Patrick's Day, basically. And that is going to be our big challenge in Supreme Court and provincial court. Absolutely.
Sides issue, court fees. Are there going to be any movements with respect to waiving court fees? I can tell you, when somebody asks us to help them and they say, Dom, I need help filing to the courts for indigent status, it takes us at least 2 hours to complete that form. And that's an experienced paralegal helping the self-rep complete the indigent status application. Flipping that aside, if you look at the CRT model, it's like an email. And you talked earlier about this fear of the public abusing the system. And when we look at the CRT experience, there really hasn't been any. And so I'm thinking, okay, is there any room to do two things? One is to simplify how a self-represented person can ask the superior court to be, and the provincial court to be classified as an indigent status. And secondly, can you sort of look at what can be done with respect to the fees during these times? I know money is kind of tight these days. Your thoughts? Yeah.
It's not something that we've been talking about because our focus has really been on triage of the big pieces of court right now. I take it really seriously what you're saying about the length of time that it takes people to complete the documentation. It's not a topic that I've addressed at all with the Chief Justice, or that has been a topic of conversation within government. So I'll take your point on that and have a conversation about it with the chief and with our staff. I believe it's probably a shared area of responsibility between government and the courts, like so many. And so that's about all I can say about that, Don. It's a very good point.
Thank you. That leads me to my final question.
Sure.
Lawyers are very powerful insiders. Through their regulator and bar associations, they can tell you what's on their minds. And I suppose you use the same relationship to go the other way. But for the average person who wants to talk to Minister Eby, David Eby. Apart from walking into your constituency office on Kerrisdale, how do they tell you what's on their mind? How do they be connected with you?
That's a great question, Dom. So for my constituents that live in Vancouver Point Grey, my office is on Broadway at McDonald. They're always welcome. And for those who aren't constituents, you're welcome to stop by too when it's open. But of course, it hasn't been open at all because of COVID. But I am very available by email. So I'll give you the email. It's ag.minister@gov.bc.ca. And people think, oh, I'm going to send an email to this guy. He's never going to read it. I read all of the email that people send me. Now, I admit, when I get a form letter and there's 100 of the exact same email, I don't read all 100 to see if there's a subtle difference in them, right? But I do read the first one. And there are people who write first drafts for me of my correspondence. But I get them and I edit them and I read my own responses before I sign them. And sometimes I write entirely my own responses because the response that I get is inadequate. And it leads me to ask for briefings and it leads me down paths of policy reform. And so it does make a difference when you write to me. I can guarantee to all of your viewers that it does make a difference when you write to me. And that's why I know that family law is such a profound issue in our province, because that is easily the #1 area that I get correspondence from people about is the family law system in our province and the need to fix it. And so it really helps me as Attorney General to know where we should be focusing our attention.
Thank you for that. That leads me to invite you for final words.
Well, thanks, Dom. I want to thank you for the opportunity to be on the show here today. I guess this is a show that you have now. It's very cool. And congratulate you again and thank you for all of your work supporting self-represented litigants in the province. And again, encourage those of your viewers who are interested to write to me at ag.minister@gov.bc.ca. And I guarantee that I'll read it.
Thank you for that. Mr. Minister, in my picture album, digital picture album, I still have one picture of the former AG Opal and you posing at the Richmond Oval, because in my bucket list,
at the basketball, yeah.
I still see you doing the jumping for AC, flanked by all these paralegals. Now, to sweeten the deal, because I know you don't play ball,
yes,
sweeten the deal, I have signed on Isaac Childs to play for our team.
Okay, well,
and he says, if
I'm telling
that's not enough, I don't know what else.
When the basketball tournament gets going again, you send me an email and you let me know, and if I'm free that day, I will definitely play with AC. I'm very excited about that personal invitation.
Thank you. Well, on that note, I know you have a lot of big issues to resolve. I wish you well, and Minister Eby, please take care.
Thanks, Dom.
All right. Goodbye.
Bye-bye.